Hey guys, the detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a brief at the Court of Appeal seeking restoration of his bail revoked by the Federal High Court sitting in Abuja. Hello everyone, welcome back to Prospect Channels TV. Thank you for stopping by. If you're just joining us, please kindly subscribe and don't forget to give us a thumbs up. IPOB leader Nnamdi Kanu files brief at Court of Appeal seeking restoration of revoked bail. Kanu said that the trial court refused to restore the bail or even order home detention in spirit of the affidavit evidence and pertinent finding of Supreme Court before the trial court. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a brief at the Court of Appeal seeking restoration of his bail revoked by the Federal High Court in Abuja. Kanu, in the brief filed through his legal team led by his special counsel, Barrister Aloy Ejimakor, said that the trial court, in a judgment delivered on the May 20, 2024, refused to restore or restate his bail revoked or the mispresentations of the Nigeria government respondent in brackets that he jumped bail. Kanu said that the trial court refused to restore the bail or even order home detention in spite of the affidavit's evidence and the pertinent finding of the Supreme Court before the trial court. The appeal brief stated that why he was on bail and in compliance with the terms of bail in Afaruku Ibuku, his hometown in Abia State, the Nigerian government devised a means of unlawfully assassinating the applicant through a later military operation codenamed Operation Python Dance, levied by the armed forces of the respondents in the said applicant's hometown. By providence, the applicant escaped assassination through casualties. Though casualties were recorded in the operation, the applicant was later awarded 1 billion naira damages for this military operation, and the judgment was on record before the trial court and later the Supreme Court. In the interim, and because of applicants' fight to safety, the respondent deceptively approached the trial court for the revocation of applicant bail on the ground that the applicant had jumped bail. The order sought was made on the 29th day of March 2019. Pursuant to the order revoking the applicant's bail, the applicant was adopted by agents of the respondents and extraordinarily renditioned from Kenya to Nigeria in June 2021, and on the 20th day of October 2021, the XY charge was amended to try the applicant separately from others with whom the applicant was initially charged. The respondent further amended the charge to include offenses relating to terrorism, on the strength of which the applicant filed a notice of preliminary objection on the 19th day of January 2022. The validity or otherwise of the charges or counts, vice versa, the extraordinary rendition of the applicant was contested up to the Supreme Court, and in his judgment, the Supreme Court, though allowed the appeal in favor of the respondent, agreed with the applicant that the rendition was unlawful, and in particular, that the applicant did not jump bail but was justified in running for his life given the circumstances of the Operation Python dance, and stated that the revocation of the applicant bill was injurious and made the impartiality of the trial court suspicious. Kanu's legal team said, "We submit that the finding of the Supreme Court, as indicated above, constitute decision by which the trial court is bound, and which does not permit the trial court to maintain that its previous finding that the applicant jumped bail subsists more, particularly when there is no appeal by the applicant against the said previous revocation of the applicant bill by the trial court." To be sure, the said pending appeal was by the applicant's sureties, and what they appealed against was to stop the trial court from taking the step to forfeit their bail bonds, not that the bail bonds were already forfeited as the trial court held. Kanu therefore asked the appeal court to determine, was the trial court right to refuse the prayers for the setting aside of the court revoking applicant bail and restoring the bail on the purport that the trial court had previously found that the applicant had jumped bail, forfeited the sureties, bonds and applicant's sureties having been charged, and proceeded to appeal. The trial court must await the outcome of the appeal when it was brought to the attention of the trial court that the revocation of the applicant bill was found by the Supreme Court of Nigeria to have been obtained by deception and made in error, and when the sureties had not in truth forfeited their bail bonds and had not been discharged. Whether in the circumstances of the instant case, the trial court rightly find that the Department of State Security, the detention facility, is a proper or safe place of custody as against transferring the applicant to an alternative place of detention, given the affidavit evidence placed before the trial court. He also, among other things, asked to applicant court to determine that the trial court had, during its previous decision revoking the applicant bill, held that the applicant had jumped bail, that the sureties had forfeited the sureties bonds and thus discharged from their bonds, and that the applicant's sureties has gone to appeal over the forfeiture of their bonds. Hence, the trial court must await the outcome of the appeal. So guys, what's your take on this? Kindly drop your comments below the comment section. Don't forget to give us a thumbs up. Share this video, let it go viral. Let Nigerians understand what is going on today.